811. There's tons to talk about. 3 hours won't be enough, but we'll do our best. If anybody can do it, it's moi, a.k.a. me. Hope you're well. All right, let's get started. In Manhattan, we have this Alvin Bragg, and, of course, we have this acting state judge, Merchan. And these two have done enormous damage to the rule of law, criminal justice, and they sought desperately to take out Donald Trump. It was the first case forward. They were in a rush. And in every respect, it was a Stalinist-type show trial. Apparently, that's very popular among the Democrats in Manhattan because it looks like Alvin Bragg will be reelected. In fact, it looks like it's very popular among the legal community, including the judiciary in New York. New York has become, I'm afraid, a legal gulag. That's right, gulag. So what happened today? Well, here's Fox. Prosecutors request stay in Trump New York case, and I'll explain this in plain English, until 2029, as defense plans motion for dismissal once and for all. What are we talking about? New York prosecutors are requesting a stay until 2029 in New York versus Trump as the president's defense lawyers prepare to move to dismiss the case. Prosecutors wrote a letter to Judge Juan Merchan today, who agreed last week to grant a stay on all deadlines associated with the conviction proceedings against President Trump in the final months before he takes office. Stick with me. You're in the right place at the right time. Merchan granted the request, which issues a stay on all deadlines, including the November 26th sentencing date, to consider the effect of his election as president. Prosecutors had asked for the pause in proceedings, which they said would allow them to better evaluate the impact of Trump's new status as president-elect. Now, as a result of the election held on November 5, defendant's inauguration as president will occur on January 20, Manhattan DA Bragg wrote to Merchan. Given the need to balance competing constitutional interests, consideration must be given to various non-dismissal options that may address any concerns raised by the pendency of a post-trial criminal proceeding during the presidency, such as deferral of all remaining criminal proceedings until after the end of Donald Trump's presidency. Bragg said his team would not oppose Trump's request to stay further proceedings, pending his attorney's motion to dismiss. And it goes on. Now, what should have happened is the judge should have dismissed the case on his own act, but he didn't. Bragg should have filed a motion to dismiss the case, but he didn't. I don't know what Merchan will do down the road, but this sort of Damocles continues to hang over President Trump. It's not a great victory. I want to walk you through this pretty much as I have before, but just a reminder, everybody's not a lawyer. Even lawyers, they're not all good lawyers. And some of them just have this damn wrong. I've been listening to some of the commentary, and they say, I hope that Merchan will come to his senses. Or, what do you expect from Bragg? He's playing to the voters there, and they want this sort of thing, so, and it goes on and on. Well, ladies and gentlemen, when you represent a client, you can't hope that things will change. You can't wait around. You need to go on offense. And so on offense, they should go because there is an avenue to deal with this. You need to get it out of the gulag that is New York, and you need to get it out of there now. Number one, we have the Supremacy Clause of the Constitution. The Constitution and the laws of the United States, Article 6, Clause 2, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. So why are we in state court when we're dealing with a president-elect? We shouldn't be. What authority do they have? Absolutely none. Zero. Number two, there's also federal jurisdiction, and that the so-called underlying offense that they use to breathe life back into a misdemeanor offense that the statute of limitations had already run was a federal election campaign issue, wrongly decided, I might add, which brought the statute back to stay and created a felony out of a misdemeanor. What else? We have a Supreme Court immunity ruling not that long ago. So key testimony from Hope Hicks while she was working for President Trump in the Oval Office and going through certain payments and so forth, that testimony is now considered unconstitutional. And then what else do we have? That's 3. How about 4? The Department of Justice memos in 1973 and 2000, which said in part this issue of deferring was raised. An indictment, and by an indictment they mean the whole trial process, can be indictment, conviction, appeal, and so forth, hanging over the president while he remains in office would damage the institution of the presidency virtually to the same extent as an actual conviction. And what they're saying there is you can't have this dark cloud hanging over a president till after his presidency. The effects will be very damaging to the office. But in any event, you're talking about a DA and a state judge. They have no authority. This case and the others were timed to influence the election. And they're now trying to use it to damage the president. A local DA and a state judge, they can't hijack the office of the presidency. So what do? According to former federal prosecutors and certain professors, there's nothing you can do. Hope for the best. Pretty much that's it. And that's baloney. You folks remember the Bush versus Gore, the 2000 case? You remember the hanging chads? You remember the disputes over ballots? You remember the massive litigation that went on in one county after another? You remember the Florida Supreme Court? All Democrats, all but one of whom was a radical leftist. The Chief Justice was not. But remember, the court kept extending the deadline, ruling what ballots were to be counted and how chads were to be viewed, always in favor of Gore, and it was getting closer and closer and closer. You remember all that? So what did the Bush lawyers do? What did the great late Ted Olson do? Did he say, you know what, we'll just wait and get a determination? No. No, time is of the essence. Did he say, you know what, we'll appeal to a federal district court? No, of course not. What did he do? Ted Olson, one of the great Supreme Court litigators, Arthur Ferguson, one of the greatest constitutional minds I know, and me, we say you get these matters in front of the Supreme Court. Now, how do you do it? The Supreme Court doesn't have a chance to decide these cases if you don't ask it. And it does have common law powers. That is, non-statutory powers, even non-constitutional powers. It has implied powers as the highest court in the country. And that's been adopted from the British system, from the Western system. And the court has done it rarely, but it's done it before. Bush versus Gore. So what did Ted Olson and the Bush lawyers do? They filed something they called an emergency petition with the Supreme Court. There's really no such nomenclature as an emergency petition, but that's how they named it, to get it to the court to see if the court would take it. And what did they say to the court? They said, court, stop the count. And while you're at it, the state Supreme Court in Florida is acting without authority in excess of its state constitutional authority. And the court took the case. Only takes 4 justices out of the 9 to say, take it. The court took the case. And the Bush team won. They won on equal protection grounds, which was kind of odd, but it doesn't matter. The court treated this emergency petition as a writ of certiorari. That's the normal statutory way in which you bring a case to the Supreme Court. But it wasn't really a writ of certiorari, since they didn't use the statutory method. They've just filed an emergency petition. What they really did, to complicate it, but I'm trying to put it in plain English, is a common law writ, which is, hey, court, We'll call it whatever. We'll call it a kumquat. It doesn't matter. We need to get this case in front of you. You're the only court with the authority to actually do something about this. Please do something about it. And the court took it, and they did something about it. That is exactly what President Trump's lawyers should be doing now, in my view, in New York. Now, it's possible Merchan in a few days, in a few weeks, he'll rule, okay, I dismissed the case, and that's great. So we don't have to worry about it anymore. But it's likely, or at least possible, that he won't. So if I were in charge of the case, which clearly I'm not, I would now move immediately on the 4 federal prongs that I already mentioned to seek from the Supreme Court the acceptance of a petition. And we can call it a writ of mandamus, a writ of whatever we want to call it. The court will decide whether it takes it, and it's not going to worry about semantics. If the court doesn't take it, you've lost nothing. Some lawyers will think, well, you humiliated yourself, you embarrassed yourself, you created a spectacle. No, this is normal, where a lawyer, an advocate, tries to find the best ways to resolve a case on behalf of their client. This is an emergency situation. This is a timely situation. Everybody's rubbing their hands together, say, we've never seen anything like this. This shouldn't be happening. Merchan should be just, okay, great. But you're not paid as a lawyer to whine and complain and to sit on your ass. I would say to these commentators. That's what I would say. By the way, I like his lawyers. I'm not attacking them in the least. I'm just explaining generally. You don't pay lawyers to, like the TV lawyers. Now, that's what I would do. I'd get this petition. I would call it, as I said, common law writ of mandamus. Call it whatever you want. The court will decide what it chooses to call it and how it chooses to treat it. Excuse me. And I happen to think, and I could be wrong, but I think I'm right, that there's justices on that court that are salivating at taking this case and fixing this so it never happens again. I'm even sneezing to the truth, Mr. Producer. That is, they don't want a DA and a state judge to be able to control the president right through his presidency as he waits for them to make a determination of some kind after he's finished serving as president. No district attorney, no state judge, no federal judge for that matter, should have that kind of control over a president who is the head of the executive branch. The state has no authority or jurisdiction right now. None. Zero. So we shouldn't have to sit on the edge of our chairs and wait for what acting state judge Merchan has to say at the prodding of Alvin Bragg. Who cares? There's so many problems with this case. The court doesn't even need to consider those problems. Due process issues, equal protection issues, how evidence was used, all the rest. They don't even have to get into that. It's unnecessary. This is a jurisdictional issue. This is a federal constitutional issue on whether Bragg and Merchan have any kind of authority whatsoever to interfere with an incoming president in preparing a new administration for the transition and then becoming president of the United States. I'm sure there are justices, a majority of the justices, who don't take this kindly, who don't like what this DA and this judge did, who don't like how they seized on federal law, which they have no jurisdiction over whatsoever, how they have violated the Department of Justice position of half a century, and how some prosecutor in Manhattan, some acting state judge in Manhattan is not going to call the shots over an incoming and eventual president of the United States. They're not going to stand for it.